I'm Athreya Mathur. I work as the Director of Legal Research at the Center for Art Law. And as a little note on the side, the Center for Art Law is a legal and research education nonprofit in Brooklyn and New York. And we discuss everything at the intersection of art and law. So whether it's got to do with artificial intelligence and copyright or restitution of Nazi-era looted art, we try to bring all of these issues and make it accessible not only to other attorneys, but to artists and art professionals, and especially researchers and students who would like to know more about the field. So if you're interested more in that intersection, please feel free to reach out and to look at the Center for Art Law, and we will have a lot of resources ready for anything that you're interested in. Now, coming to today's program, I thought the best way to begin would be to let you to take a look at the images that you see here. And I think it's important to note that these are actually two separate images that I created using Llama AI, using Meta AI. And I was wondering if I could ask you all if you think there are any familiarities in these images that you see. Are there any artworks that you recognize? Yeah? A couple of emerging artists, maybe Van Gogh or something of the sort here. Yeah? So I spent a lot of time creating these images, not just one, but two of them. And now I'm presenting over here using it as the opening slide for this workshop. Now, is this right? Is this my artwork? Now that I have generated these and I'm using it, who owns the images that you see here? Is it me? Does it belong to me? Can I do whatever I want with them? Does it belong to the artificial intelligence? Does it belong to Llama AI who created them? Or does it belong to the creator of Llama AI, Meta, who created the artificial intelligence? Or does it belong to nobody at all? And these are just a couple of questions to keep in mind. And like I said, when I was generating these and when I was working on them to test out a whole bunch of things, I used the names of some artists to see what it would generate. And I used sunflowers, I used Monet, I used Van Gogh's Starry Night, and I recreated this in the style of an oil painting. And I wanted it to imitate actual brush strokes. And this is what it came up with. Now, it looks a little vibrant, it looks a little engaging, and it captures people's attention. Now, is it right for me to use the work of another artist and incorporate it into prompts and generate something that uses the likeness or the work of artists who you might know? Is it moral? Is it ethical? Is it legal? Am I allowed to do it? What happens to these images here? And why am I stressing on the fact that there are two of them and it's not just one image being generated? So I hope that this leaves you with a lot of questions. And by the end of this presentation, while I hope to give you some answers, I'm afraid that you'll have more questions. And we'll see how we can work through them and how we can resolve them. But keep these images in mind and keep some of these questions about not only the legal considerations, which we're going to discuss, but the ethical and the moral considerations that you may have to think about either as a lawyer, either as an artist, or very simply as a user of any of these platforms. And I thought a good way to begin today's presentation would be to show you how certain artists or how creatives are using artificial intelligence in general and how they're using to create. But as also a very quick note, this is an educational presentation and it doesn't amount to an attorney-client relationship. But apart from that, we will go into some of the uses of artificial intelligence and what creatives are doing with it. Now, last year, I stumbled upon an exhibit in Brooklyn. It happened to be right opposite our office, actually. And this was a human-assisted artificial intelligence art exhibit. Now, whatever that means, we can try to understand. But essentially, what this exhibit was showcasing were all works, all creative works that were primarily created by AI. And one of the things that I saw, which really captured my attention, was this poetry camera. And this is a camera that was created by Caroline Zhang and Ryan Mather. And it looks very similar to any Polaroid camera that you would see. But it operates on Raspberry Pi and GPT-4, so it runs on artificial intelligence. And when you use this Polaroid camera to take a photo of somebody, instead of printing out a photo, it prints out a poem based on the image that it captures.
Wow.
And initially I thought that, oh, this is going to be a really, really cheesy two-liner poem or something of the sort. But we took a couple of photos and it generated quite long and interesting poems, enough to keep us entertained and to think about it a little bit more. But once again, now that this poem is generated and I am the proud holder of this AI-generated poem, is this mine? Is it the creators? Is it artificial intelligence? What can I do with this poem? The fact that it's up here and you can read it, can you copy it? More questions, no answers. But I do want to mention something interesting about the poetry camera and the creators of this is that they've actually made it open source and open access, and their goal is to make this into a do-it-yourself, build-it-yourself poetry camera. So they've given you all of the files, all of the code on how to use it with artificial intelligence, so you can change it and create poems in whichever style you would like with artificial intelligence. And another really interesting part of the exhibit, not much related to art, but something that was slightly strange, was taser chess. And over here, you play against an algorithm, you play against AI, and you have these electric nodes attached to your hand. And if you play a bad move, or if you play a wrong move, you get little shocks administered to you. So once again, interesting, concerning. We will see about what exactly this means. Now, bringing it back to the art industry and bringing it back to something that you may or may not be familiar with right now is this humanoid robot. Is anybody familiar with this thing? No? All right. Well, this is a humanoid robot named Ida. And Ida was created by a gallerist and was named after Ada Lovelace, who was the first programmer. Wow. And what this humanoid robot created, what Ida created, was a portrait of Alan Turing, who is one of the foundational figures of computers and one of the first people who spoke about artificial intelligence. And Ida, this robot, created AI God, which is the portrait of Alan Turing. And it draws on various it draws on Picasso, it also picks on George Orwell. And what this painting depicts is the relationship between humans and artificial intelligence now and in the future. Now, the reason why I am bringing this up is because this piece was actually auctioned off at Sotheby's. And the estimate for how much this work would sell for was about $140,000 to $160,000. And does anybody think that this work sold?
Yes. Yes.
How much do you think this work costed?
10 million.
4 million.
All right. Well, it sold for a little over 1 million. It was $1.08 million after an estimate of $140,000 to $160,000. Now, something which we'll get to in a little bit, which relates to copyright and ownership, and the difference between copyright over a certain piece and owning a certain piece. And just because you have physical ownership over something does not mean that you have the copyright over it. So that's just a little clarification that I want to make sure we understand before, because my next question would have been, this work sold. And as I have been asking since we began this presentation, who owns AI God? Who owns this? Is it the robot? Is it the creator of the robot? Does anybody know? Or is it the person who's now purchased the piece? Yes. And does it matter?
Yes, it's a person.
So we'll answer that question, I promise, very shortly. But I'm bringing this up is because the person who purchased it, who is a private purchaser, private ownership of this work now, did not care about who had copyright over it. In fact, the art market did not care at all. They wanted to own some sort of a statement piece that was generated by this humanoid robot. And this ultimate photo that you see, AI God, it belongs to nobody. So this, you're seeing over here right now, anybody can use this image and use it for whatever purpose they want. And we'll answer why in just a minute. But it's important to note that while we're here, and I'm very glad that we're here and we're discussing so many of these important topics, but a whole part of the community, the art world, does not seem to mind about who the creator of the work is or who actually owns it, as long as you're able to hold it. So keep that in mind once again. And
Well, who did the money go to?
the money went to the gallerist. So that is a very good question about who is commercializing and who is actually earning and who is getting any kind of monetary or financial gain from the works that are being generated. And that's also what we'll see with all of the AI platforms we're using. When we're using ChatGPT or any Midjourney image generation platforms, who gets the money? It's OpenAI, it's the developers. So it's a very good question. And we'll kind of delve into all of these. I'm already worried that we're not going to have the time to cover a lot of issues that could arise. But today I really want to focus a little bit on copyright, on authorship, and a lot of the questions that we've been asking. That if you have generated this AI work, who owns it? Who is the author of it? Is it the person who is inputting these text prompts and creating? Is it the AI in itself? Can AI ever own something? Or is it always going to be the developers? And if so, who is responsible if there is infringement? How are all of these AI softwares and platforms able to create? Whose work are they taking in order to generate this work? They're not coming up with all of these ideas. They're not coming up with all of those Van Goghs you see for the first time. This is trained on already existing works and likely already existing copyright protected works. So we are going to look into authorship, we're going to look into ownership, we're going to look into infringement, that if you are data scraping and taking things off the internet, are those copyright protected? Is that something that belongs to everybody? Or do you still have copyright over that? And if you are data scraping and taking out all of these images and information and data, are you allowed to do it? Is the use transformative enough to make it fall under a defense known as fair use in order to allow for training and education to take place? There are also a lot of other issues that I won't likely be able to get into, but we will cover what happens if you create in the likeness of a certain artist. If I ask AI to generate something in the style of Van Gogh or in the style of a living artist that we know, is that okay? What is the difference and why does that matter? There are also a lot of other concerns, such as right of publicity and creating something which resembles another person. And that's a little beyond copyright, but goes into another right known as the right of publicity. We'll go into that and see some of the issues that come up. There are also tons of other things that I do want to mention. There is a lot of racial bias in training. I don't think we'll be able to discuss all of that today, but I remember when I was testing out a couple of platforms, I asked the image generator on ChatGPT to generate a portrait of an art lawyer in the city, and it was a very old white man sitting in a building. So it was interesting to see what inputs and what information it takes and what it generates. So while there are other issues such as racial bias in training, a lot of data privacy, when you are pouring your heart out to artificial intelligence and to ChatGPT, as people are, and they're using it as a therapist at this point, what happens to all of the information that you're giving out? Can it be accessed by just anybody? We'll slightly discuss this, but that is a topic for a whole other time. There are also a lot of issues with deepfakes and creating images that look like other people. And there are laws, I will say, that are coming out related to that in different policies, mainly because of child pornography laws, which are strong, especially in the US, but that is essentially the only thing that the laws are really developing to cover. And a lot of the issues and questions that I've asked and posed today, just in these last 10 minutes, are still being looked into, they're still being answered, they're still being analyzed, and we haven't really heard from courts about a majority of these. So we have no precedence, which is why, like I said at the beginning, you might have more questions than answers, because this is a topic everybody seems to be working on together, and we can sort of analyze the issues and the challenges and what is happening right now and what the best practices would be going forward. Whether you are an artist how to collaborate ethically and responsibility with AI platforms, or whether you are a developer and how do you get the consent of artists and what are you supposed to do, or just developing the best practices for artists to ensure that their work isn't stolen and isn't fed into the systems and their work isn't being regurgitated by AI platforms. So these are some of the things that we will be discussing, and we'll get into all of it very soon. But in order to get a better understanding of so many of the questions that we're going into and that we're asking right now, it's important to know what exactly is copyright and why do we care about it so much? Why are we continuously talking about it, encouraging artists to think about it as well? So copyright is a form of intellectual property. It is a creation of the mind, and it is how that form has been expressed. So when you move it from an idea into an expression, that is something that can be protected under copyright, whether it's a pictorial work, a photograph, visual art, architecture. There is some copyrightable element in front of you. You're looking at the slides, you're looking at an image, you're looking at a poster, you're looking at a menu. There's something copyrightable to it. Even the architecture in front of you, the chairs, the design, there is something that is so creative about it. It is something that you have created in your mind, and you deserve protection over that. So that is exactly what copyright is. It is a bundle of rights, of exclusive rights, that is given to the person who has created this work, and you, as the author and as the owner of that work, can do whatever you would like to do with it. Now, a little distinction between authorship and ownership. One is copyright is granted the minute you create something. So if I stand here right now and write a poem, or if I sketch something, no matter how bad it is, I actually have copyright over it. I don't have to do anything. I don't have to register it. It is my work. It is my copyright. However, if I do register this work with the Copyright Office, you get a lot of benefits. And if your work is not registered, you actually cannot bring an infringement suit. So having your work registered is the only way to bring a lawsuit in federal court. That's just something you have to know. While copyrighting your work with the registration office is not a necessity, it's not mandatory, it does have a lot of benefits. It shows prior use, it shows that this is your work, it shows validity, but more than anything, it allows you to sue. And if you do not have your work registered, and if you join a lawsuit, you will see what happens. Your claims are dismissed, and you can go back, and of course you can register it, but you lose statutory damages. And that means that you have to prove actual damages, which can be a little harder, and the litigation aspect of intellectual property is very, very expensive. So that's just something to keep in mind. Now that is authorship, the person who creates the work, whether you're an author, whether you're writing a book, you're a poet, you are an artist, you're creating an oil painting, you have created it, you're the author of the work. And generally, whoever is the author of the work is also the owner of the work. An owner is somebody who has all of those exclusive rights and can do whatever they want with their work, because not only did they create it, but they have all of those rights to it. Now, the reason why these are different is because if you have a licensing agreement, you are allowed to give away some of those rights to another entity. So then that entity has some ownership and has control over the work that you're doing, or how the work would be distributed. And very common examples of this is that if you are an author and you've written a book, then you want to license certain rights to a publisher so they're actually able to get it to the market. So that is the difference between authorship and ownership. One of the biggest exceptions to the whoever is an author is also the owner rule is usually employer-employee relations or a work-for-hire arrangement. So if somebody has employed you to do something or has hired you to do a specific task, then you're doing it for them, and it's on their time and it's on the company's money, so you would not be the owner of those rights. Now, I mentioned this because it is essentially the base of everything that we're going to be discussing and why it's so important to understand what copyright protects. A couple of notes about when your work can receive protection is that your work has to be original, it has to be fixed in a tangible medium of expression, and it needs to have a modicum of creativity. Now, I stress upon that because your work doesn't have to be so creative that it should receive protection. Like I said, I can just jot a poem down right now, And as long as I'm not copying it from somebody else, as long as it's original, I've written it, it's in a tangible medium of expression, and it's tiny amount of creativity that I've used, that allows me to have copyright over the work.
Yeah, I have a question about the tangible. I'm a choreographer,
Mhm.
and I'm also a writer, but I've had people where I premiere work and they sort of pirate a video and then they use it for whatever.
Mhm.
When you say tangible, is the dance only copyrighted if it is documented, notated, or videotaped? Because it is an ephemeral art form. It only
Yes.
exists when it's being done.
It is possibly one of the most frustrating areas of copyright law because choreography, dance, short form dance, essentially the only way for it to be protected is if it's written down in a routine, if it's documented, or if it's recorded on some sort of a film. So it is complex and it's very unfortunate because we've had a lot of cases, especially in the recent years, with social media platforms and TikToks that got very, very popular because people would recreate dances and then they would do these dances in their own way and add another step to it. And a lot of the times the office said that these short form dances and these movements, these body movements, cannot be copyright protected. And if you have a full choreography, a full dance that should be protected, it needs to be recorded and sent to the office. So we'll discuss a little bit more maybe about conceptual art and ephemeral art, which is just a little frustrating because how do you show that this exists?
Yeah.
Mm-hmm.
And it's also true if you have former performers, they go off on their own.
Yeah.
And then they just decide to do your program.
Yeah, and it's
With no credit or not asking you.
it's one of the easiest forms to copy and to reproduce. So there are different ways to potentially protect that, which we'll talk about. But now you've understood what copyright is, and you know when something can be copyright protected. And I really want to stress upon the fact that copyright protects an expression. It doesn't protect an idea. So if I'm just thinking about a poem in my mind, and I'm kind of like reciting words a little bit, it's an idea and it can't be protected. But if the minute I write that down and it turns into something tangible, if a video of me is being recorded of me speaking this poem out loud, or if it's become expressed in any sort of way, then that is an expression and it can be protected. Now there's a lot of sometimes misunderstanding between what is an expression and what is an idea, and I will go into that dichotomy in a moment. But I want to mention something very important which will guide us once again through this presentation, is that the Constitution of the United States has an intellectual property clause, and this kind of discusses what the goal and what the objective of intellectual property and copyright is. And while copyright and IP rights, they are there to make sure that you as artists have economic incentive to create and you have some economic rights, the point and purpose of copyright and IP is to promote the progress of science and useful arts. And so you grant these economic rights, but people need to be able to build on creative works. You can't inhibit or stop somebody from creating, which is why copyright lasts for the life of the author plus 70 years. And after that, it goes into something known as the public domain. And the reason for that is essentially the whole idea and expression dichotomy and what can be protected and what should not be protected. So photographs, oil paintings, dance and forms, it's all protected forms. But what is the difference when we look at something being expressed or just having something in mind that people should also be able to copy? Now, my favorite example to understand the idea expression dichotomy are rom-coms, romantic comedies. And I watch many rom-coms. No matter, I know exactly what's going to happen in them, I know how it's going to end, but I'm just sitting there and watching them. And I'm a big fan of the whole chasing someone at an airport cliche. I'm like, okay, this is gonna happen, everything is okay. And you have a lot of these types of scenes. You have somebody with a boombox, somebody professing their love, chasing somebody at an airport. And all of these are actually just ideas. And if you start to copyright these ideas, we'd have to watch one rom-com for our whole lives. And that is not something I would like. So the reason why we have this intellectual property clause and we have this clause in the Constitution is so that other people, other movie makers, can take these ideas and they can produce it in different ways. You cannot copyright facts. You cannot, we watch so many different period dramas, for example. And the reason why we're able to do that, why we're able to see so many of them, is because all of these producers and movie makers are reinterpreting it in different ways. And that is because no monopoly can be given to ideas and to facts and to these historical. But the movie in itself is protected. That is the expression. And so if you take a little clip of a movie and post it somewhere, that is infringement. But the idea of recreating a scene like this, that is very much allowed. Now we're finally coming to artificial intelligence. And why that background was so necessary is to understand how these works are being created and how these authors are trying to have their works protected, and whether it's something that you think should be protected. Now, a very classic example, one of the first registrations ever received by the Copyright Office was Zarya of the Dawn. And this was created by a graphic novelist, Chris Castanova. And what she has done is that she created this graphic novel using images that were generated by Midjourney, which is an AI image generation platform. And she used Midjourney, created these images, but it's essentially a comic, right? So you have little text boxes as well, which is what she wrote. And you'll see that these images, which is a different issue, they kind of resemble an actress that you may be familiar with, Zendaya. And is that an issue that we should talk about right now? Probably, but we'll discuss it in a bit, about right publicity. Over here, she generated these images using artificial intelligence, using Midjourney, created the little text, and sent it to the Copyright Office saying this needs to be protected. The Copyright Office granted full protection of the work. And then there was a lot of ruckus that was created on social media when it came to light that these images and this work was AI generated. And it's interesting to note because on the cover of Zarya of the Dawn, it was written Midjourney very clearly. The artist wasn't trying to hide that it was generated by AI, but she didn't particularly disclose it. And once the Copyright Office learned that these images were AI generated, they rescinded full protection over the artwork. And they said this is not going to be protected under copyright. However, the selection and arrangement to the human attributable components would be protected. So what that means is the text with the images, that would be protected under copyright. So essentially nobody can take like an exact copy of this page and do something with it. However, if you pull up the images and use them, if you take one of the images that she generated, put it on a tote bag and sell it, you're absolutely fine, because these images are not going to be granted copyright protection. What the office stated, and I'll get to that in a little bit, is that the author needs to be human. So that leads us to another little backdrop case. And it's a very popular case.
Is it the author or the creator?
The
Author or the creator?
So there's a little distinction. So the author in this case, or who we're referring to as the author, is the person who's inputted the text prompts.
Okay.
So in Zarya of the Dawn, the author or the creator is Chris Castanova. And this person had generated the had generated the images and then added her human component text to it as well. So the Copyright Office said is that this work is protectable to the extent of the human created parts. And that is it. The AI images would not receive protection. However, the selection and arrangement of the AI components with the human created components, that can be protected as a whole. So essentially it's a very narrow copyright protection that is being provided, because you can easily take these individual images out and you can use them for something. You literally just can create a copy which has the comic text in it and the images in it. Now, we have this lovely monkey, and this is Naruto, and this case was very, very popular, Naruto versus Slater. And we had a British wildlife photographer, David Slater, who created this book. And in this book, there were a number of selfies that included a selfie of Naruto. Now, the wildlife photographer Slater had set up a camera and he had left it unattended, and Naruto decided to take some really striking selfies when the camera was left unattended. And when he took them, they came out like this, and it's quite beautiful and impressive. So Slater had included a whole bunch of these selfies and photographs that Naruto had taken in his book that was published. And all was good. Until PETA, the People for Ethical Treatment of Animals, said, hey, you know, this monkey should receive copyright to those images that he took just as a human author would. And the Copyright Office said, no, that is not the case. While the Copyright Act in the United States does not necessarily define who an author is or state that an author needs to be human, through cases such as these, we see that the office has repeatedly stated that in order for a work to receive copyright protection, the author requirement needs to be a human author. And what they further stated is that the author has to be human, and it cannot be a machine or anything that was created by mere mechanical process or anything that was reproduced randomly or automatically. And that leads us to a very big question of artificial intelligence. There needs to be enough creative input on behalf of the human author, the human creator, for a work to receive copyright protection. So what do we get from this? What do we get from Zarya of the Dawn, the registration that we just saw earlier, and from the Naruto case? One, author has to be human. And the Copyright Office also stated that all of these cases that are going to be heard about, whether in AI generated or any monkey or elephant created artwork would receive protection, it's going to be decided on a case-by-case basis. And if your AI generated work is a result of that mere mechanical process, or simply entering a text prompt, that is not going to be enough original mental conception. And these are the terms that have been used by the office. There needs to be enough human creativity. There needs to be the human's original mental conception, and that is when a work could receive copyright protection. It also stated that in order to grant this protection, anything that is solely AI generated is never receiving protection at this point. And things could change very quickly, and we'll go through some of the cases that show how this has been interpreted and how that's changed. But at the outset, anything solely AI generated, never receiving protection. Now, if there's a human collaborator, a human component, the human created aspects of that work would receive protection to the extent that the human created them. And it would be protected as a selection, arrangement, and coordination of that AI material and the human created material. What we were discussing with Zarya of the Dawn. The images, not protected. The text, human created, protected. The selection of the human created text with the images, selection arrangement, protected. Now, it also very specifically stated that any applications that come to the Copyright Office, if it has some AI generated components, that has to be disclosed. And if it's not disclosed, your registration will be canceled. In fact, it won't be accepted. Now, after Zarya of the Dawn, the artist Chris Casanova got a little upset. The artist thought that she put a lot of energy, a lot of effort, and was very sad that the Copyright Office rescinded full protection over her graphic novel that she created. So she decided to do something else and to kind of test the office. So I always recommend following Chris Casanova because she's doing incredible things and really testing the limits of the law. But she created Rose Enigma. And Rose Enigma, as you'll see, this is the initial sketch that now Chris Casanova, the artist, inputted into the AI platform. And now she's sketched something, and she's put in her own work to tell the AI platform to create the artwork that she wants in a certain way. And you'll see that she also really specifically put in detailed text prompts. She put in her own sketch. She talked about the CFG scale number, how many sampling steps would be needed for this artwork to be generated. And the Copyright Office essentially stated the same thing. Now, the attorneys for Chris Casanova, who helped with the registration filing, stated that, you know, this was exactly what the artist had in mind. This was her original mental conception. This is what she wanted and she envisioned, and this is what AI created, and that should grant the artist protection because it has that original mental conception, that component. But the Copyright Office reiterated that anything purely AI generated would not be protected. And the human aspects, the sketch, that would be protected, but essentially, if you're creating something and the ultimate output, the heart of the work is generated by artificial intelligence, you are not receiving protection for this. But what's interesting is just observing and understanding the artist's perspective and seeing how the original Zarya of the Dawn, a full graphic novel, did not receive protection by simply putting text prompts. What if you start inputting your own sketches and your own artwork? How does that affect it? And this kind of shows that, once again, anything purely AI generated, not protected. Now, throughout all of these examples, and even right at the beginning when I showed you the images that I created, I told you that it took me a lot of time, and it took me a lot of effort. And it took Chris Casanova so much effort and so much time to create the things that she is creating. So I asked that because in this case, the Theater de Opera Spatial, created by Jason Allen, he had over 1,000 text prompts in order to generate the image that you see. Now, he used 1,000 text prompts in order to get this image, which is the AI-generated image. And then he worked on it. And you'll see that there are a lot of edits, there are a lot of details, there are a lot of specifications that have been added to his version. And this was submitted for a contest at a Colorado State Fair, and he won. And it later came to know that this was an AI-generated piece, and the other participants were pretty upset. But the organizers of that competition did not really mind. They said that we didn't prohibit anybody from doing that. So, you know, it's okay, while the other people were upset. So then Jason Allen, after winning this Colorado State Fair with his AI-generated artwork that was worked on to this extent, then submitted it to the Copyright Office to get it protection. Do you think he got copyright protection for this artwork?
No.
What did he do the work, after he did that, then he did more detailed work. What did he do the detailed work in? What are you saying?
He's a digital artist, so he used various digital
Midjourney or
tools
something
to,
like that?
yeah, and even like more classic, like Adobe Photoshop, a lot of different tools to just create these edits, to create this sphere that overlooks something. And this is apart from the thousands of text prompts that he used to get it.
You got some copy.
So then Photoshop, he did the work.
The work?
Yeah.
Except that, pardon me, but Photoshop has so much AI implemented within its program that, for instance, sharpening the image of the woman with the red robe could be done via Photoshop AI. So he worked on it, but he didn't really do the work. I mean, it takes a lot of hours to do Photoshop, I know this, but still, in the end, it's who's doing the work, quote unquote work. So.
All right.
And if he used it as a reference and created another painting from that reference, where is that go?
We will discuss that right in the next example. But for this, I mentioned the 1,000 text prompts a good few times to show you that that does not matter. And there was a doctrine under copyright law a little while ago called sweat of the brow. And that meant that you put in labor, you put in effort, and you receive copyright for it, but that doctrine has been completely done away with. And it doesn't matter how much time, how much energy, how many hours you put into the work, as you stated. It doesn't matter.
Would it matter if you had done it like used paint strokes, for instance?
Yes.
Would that change it?
it would slightly change it. And I think the next image that you see will be a good representation of that. But,
Do you know what AI tools he was using?
Not specifically, but many. The original was generated by Midjourney. And then he used many different types of tools in order to recreate this. But sweat of the brow doctrine is completely done away with, so it doesn't matter if you have one text prompt, it doesn't matter if you have 1,000,000 text prompts, it's not going to help. And this was,
Was his original concept the basics of this image, namely a circle or a sphere, people standing around, some light coming in? Was that in his original concept?
that's what he wanted to do. So with all of the text prompts that he had used, this was the best that AI could reproduce independently. And then you can see that there were little pieces of it missing. So he wanted to further enhance that to get exactly what he had in his mind. And then this was the result.
It seems like the law or the way things are being judged depends upon the amount of creativity or the amount of conception. And it seems that as we move forward toward simplifying the bridge from concept to execution, and as that's made more simpler, for example, if I have an image in my mind now, which I have one, I should be able to copyright or protect that image without having to execute it. Sweat of brow, brush stroke on the canvas, or prompt. So does that play into it, trying to look forward on as we simplify the execution of it?
So very, very simply, when you're thinking of something or you have a certain concept in mind, if it's not expressed in any way, there is no copyright. So an idea itself would never receive any sort of copyright protection. And then if you're trying to bring this idea through life with artificial intelligence, such as in this case, then something that's simply AI generated also does not receive protection. But what you're saying is very close to what we are coming to. It's about the creative control that the author, the creator, would ultimately have on the final output, to see how much of that original mental conception the author had in mind and then actually did it in order to get it there. Not just orchestrated, but actually contributed to the work. So like, for example, in the very first image that I had showed over here, this is actually pretty much in the public domain. I worked really hard on it, and I really hope nobody steals it, but it is essentially free for all to use. I can put it on a canvas and I can sell it. You can put it on a canvas and sell it. And the reason why I stressed upon the fact that these are two images is exactly what we have been talking about. It took me a long time to generate this. All well and good, I don't have any copyright over it. It took me even longer to generate the second image to make sure that it looked complementary to the first image, in the same tone, in the same brush stroke, using the same kind of flowers. It took me forever to get a second image that looked similar to this, and to be sort of a series that I had in mind. And what does that say? I thought about it. I kept thinking about it. I'm like, this is what I want. Why isn't it happening? And it's simply because I could not control the ultimate output of what AI was generating. I tried quite desperately, but
I just want to go back to where you were at the Constitution to reiterate what protection we had. And also in this picture with your Starry Night by Van Gogh, doesn't he have his own copyright? And are you allowed to put that in yours?
So, good couple of questions over there. To answer the first one, the US Constitution simply states that you have economic rights as a copyright holder, so you should be able to get something economically out of the works that you've created. However, it is limiting in the sense that you can't be granted any monopolies over certain ideas or even a period of copyright for something that extends over the life of the author plus 70 years, so that other people can build on it and can create from it. So this is a little different. This is talking about the extent of copyright and what the purpose of copyright is. The Copyright Act in the US of 1976, that protects original works of authorship. That grants copyright protection, and it gives you a set of exclusive rights, the right to create, to distribute, to earn money from it. And we'll get to the second half of your question very soon when we talk about creating in the likeness of another artist. And right now, we're discussing about like the authorship and the ownership component that somebody is creating this, who owns it. Next, we'll discuss, now what if you're creating in the style of a certain artist? Is that something that's protected? Van Gogh is also a really interesting example because our works in the public domain, is it past the life of the author plus 70 years? So yeah, it's important to note that some works are now in the public domain and you can use whatever you want with it and you can do what you want with it. And Van Gogh is a really good example for that, especially with Starry Night, just because you now see so many recreations and derivatives of it. You have the New York skyline in the style of Starry Night and a whole bunch of different types of artworks that are created similarly to works that could be in the public domain or not.
Thank you.
Of course.
Are artists that make photographs, are those photographs copyrightable?
Artists who make, so
Photographs, because they use a machine.
yes, absolutely. So photography is a form of art, and the minute you take that photo, the person who clicks the photo is considered as the author. So photographs are protected under copyright. It is a very interesting subject matter. I think one of the biggest cases that I would always recommend for anybody to read is the Andy Warhol case, Warhol versus Lynn Goldsmith. It was relatively recent, and I think when I was hearing, I actually heard the arguments, and I had heard one of the judges make a comment on how anybody can be a photographer these days with with an iPhone and things like that. And it was a little upsetting because photography is a form of art, and I think the ultimate judgment in this case, I won't go into it, but I recommend reading it, reiterated how photography is a form of art. And if you're using somebody's artwork and creating a screen print of it, or creating some kind of a statue, or some kind of a model, or some kind of other form of artwork based on the original photograph, that is infringement, and that does not fall under fair use. Now, hopefully we have understood a little bit about what copyright is, what it protects, and the fact that right now anything that is generated by artificial intelligence does not receive copyright, mainly because the author is not human. And for copyright to subsist, the author needs to be human. Now, these are all copyright registration letters. Right now, we have not got into any legal cases, any litigation. Right now we're talking about artists submitting a letter to the Copyright Office saying, hey, this is my work and I would like it copyright protected, and the office either saying, yes, you're going to receive protection, or saying, nope, you have no protection. Now, that is important for you to get the base of who is the author, who is the owner, and why does this matter so much when you're inputting text prompts. Now we're going into an actual case in Thaler versus Perlmutter. And this is a very interesting, very exciting case because Stephen Thaler, who is a scientist, and he created an entity known as Creativity Machine. And Creativity Machine, which is this AI entity, created an artwork called A Recent Entrance to Paradise. And Stephen Thaler had some very interesting thoughts, saying that one, this recent entrance to paradise it deserves copyright protection. And he appealed what the Copyright Office had stated, which did not grant it protection. He appealed it in court, saying that this artwork should receive copyright protection because I was the author of it, and another note, I created this AI entity, Creativity Machine, and essentially hired Creativity Machine to create A Recent Entrance to Paradise. So can I not own it in the sense of an employer-employee relationship or some kind of a vicarious relationship like that? And can I not be considered as the author of it and therefore get protection of it? But the Copyright Office and the court, what they stated was, no, we're not even going to deal with this employer-employee relation when there is no copyright in itself. And this artwork, completely generated by Stephen Thaler, was solely AI generated. So it's not even like the other registrations that we've seen, because Stephen Thaler really didn't do anything with the ultimate output of the work. All he did was instruct Creative Machine, this entity, to create it. And because there is no copyright question at all, a question of co-authorship or a question of employer-employee relationships does not even arise. Now, the reason why I mentioned this is because it's one of the biggest cases that got things going, and it was one of the first decisions of a court where we received some kind of a guidance besides the Copyright Office, a federal entity, that the courts are stating that you cannot really appeal this. And I wanted to mention in Jason Allen's case, the same thing happened. It had gone to court, it was appealed, and now it is gone to court again. And Jason Allen is appealing it for the second time to see whether this can be granted protection. So everything that I am saying right now is continuously developing. And maybe questions will change. I've spoken to so many other attorneys. We were just at an event the other day, and one of the attorneys stated that I think text prompts should be enough for copyright protection to be granted with how creative they're becoming. And right now the Copyright Office is vehemently against that, saying that simply having text prompts, no matter how long they are, no matter how many of them you have, or how creative they are, it's not sufficient enough because there's no control and no creative control over the ultimate output of the work. Here?
I have a question to go back to, you were talking about Photoshop earlier, but not just Photoshop, other software that aids in the creation of the work. For example, Procreate, which is a drawing program. So you're physically doing the drawing, but you're doing it through this program. That and with Photoshop, you created, let's say you created a photograph and you're doing the the work to it to improve it or to make it enhance it. The same kind of thing that you would have done in a darkroom, but digitally. So I'm just curious how that fits in.
Sure thing. So in Zarya of the Dawn, you will see that the graphic novel, it was essentially created by Chris Casanova using Midjourney. And then after those images were generated, the artist used Photoshop to enhance it and to edit it. And that was not any additional AI. That is something that she had done personally and with her own hands to digitally enhance these images.
Yeah.
And the Copyright Office stated that just using Adobe Photoshop to make these edits on an already AI-generated image is not enough human creativity or human involvement for it to receive protection. However, if you've taken a photograph with your camera and then you use artificial intelligence to make certain edits to it, that is the opposite. That would likely receive protection because the underlying work is created by a human, has been taken by a human author. So if you use little edits on Adobe, and a lot of these platforms, as we have been discussing even before we started this conversation, we were talking about how whether you like it or not, a lot of the platforms, a lot of the websites that you're using, they have AI integrated components at this point. Google, Gmail, Adobe, whatever application you're using, Instagram, AI has been integrated into it.
Right.
And those are a little different. We'll be discussing a little bit about what generative AI is, which is what we're seeing over here about how all of these images are being created by artificial intelligence from scratch. And we'll also look into assistive AI, which is about editing and maybe researching and what the difference between them is. Right now, courts aren't really, they don't care as much between the difference of it, and we'll discuss this when we talk about data scraping, because you're essentially pulling everything that you would have in any case, and you're using it either for generative output or you're using for assistive output. All I can say is that this is on such a case-by-case basis. Every registration or every court hearing, such as Thaler versus Perlmutter, the decision could change very quickly, but from what we can see, and some kind of a guidance, is that you take a photograph by a human using a camera all good. You use AI to enhance it, still all good. You'll be in the clear and it would still receive protection. If it's the other way around, AI generated image using Photoshop to make enhancements, likely no.
Taking this like to writing, what if I was writing my memoir, but my prompts were all to AI saying, this happened to me when I was a kid, and this happened, and then it's written. But then I edit it. Who owns that story?
That is also a little layered, a little complex. Now, if you're using it as an assistive tool in the sense that you're simply dictating and it is writing it out, and a lot of applications like this, I think it's Otter AI, also exist for recording meetings, but ultimately the words are yours, then it likely would be fine, and it likely would be in the clear. However, you would have to denote that this used AI for so-and-so purpose. That is the only thing. So the disclosure requirements are needed, but it would likely receive copyright protection for that. It's great to see that there are so many questions, and it's amazing because there's so many different forms of art, and the way that the courts are even handling different forms of art is very interesting. So we'll get into why it can be a little different for authors, and books are actually the biggest cases that we're seeing right now, the Authors Guild, and we actually have a little bit more to go off of them. The other visual arts cases are very slow and have been stuck procedurally for a little while, but we'll discuss the stages of those too. Now, the most recent image I will discuss is a single piece of American cheese, and that is the image that you see over here. And what was interesting about this is Invoke, which created this image, had used a process known as inpainting. So whatever AI generated image that was initially there, by using the process of inpainting, you took various squares, various pixels, various portions of this image and further edited it using more prompts and using more details from the human to edit each component of this image. And apart from that, the image was also evidenced by time lapse to show the human creativity and the human work that went into creating this. And this did receive copyright protection as a selection and arrangement. And I think the biggest difference over here was actually this time-lapse video, where the Copyright Office got to see how the work was actually being created and what human edits were being added in. And it makes you think that some of the images that we saw over here, for example, maybe this could have received protection if it was documented in a different way, or if it was a selection and arrangement of something. So the Copyright Office, which is now shut down, by the way, so we're not hearing anything new from them, but they are still accepting registrations. The Copyright Office granted registration for this work as a selection and arrangement. They were able to see the number of iterative edits that the human author created. They were able to see in the time lapse the process of it, and kind of probably more convincing that, oh, this person has done this, and by using the process of inpainting has edited every single portion of this. It makes it look like it's more work. I don't really know the full technical process of creating this, but it was granted copyright protection. And I think that's something to keep in mind as an artist who is testing out artificial intelligence, if that's something that artists want to collaborate with, is documentation, and to know what the process is, which softwares you're using, and very importantly, what are the edits that you're adding in, what are you creating, what are you inputting, and what the original AI generated image is. If you are tracking these steps, and if you are keeping a good record and good evidence of all of the AI versus human generated components, then you may have a stronger chance of having your work copyright protected, just in comparison to some of the cases that we have seen. Now, this is a question that I think you brought up, and maybe you as well. What happens if you have an AI generated painting or AI-generated artwork, and you're simply inspired by it. Over here, wonderful artist Colleen Hoffenbacher had the chance to speak with her and to learn more about her works. She had created the top left images that you see over here using artificial intelligence. And then she was very, very inspired by the work that was created. And one of the issues with this AI-generated art is essentially in the public domain because nobody is an author and it's not granted any copyright. So when you have all of these images that are being generated by AI, anybody can see them, anybody can use these images as is, anybody can be inspired by them. However, if you copy this, as in if you take a photo of this, or if you reproduce Colleen's work, the oil painting in itself, which is different from what you see over here, if you reproduce exactly this, you'd be infringing on this artist's artwork. But if you're simply inspired by this and create something that's like that or something similar, you're fine. Which is why Colleen actually has very narrow protection, if you think about it, in the sense that the only protection she has over this work is that it cannot be fully directly copied.
With that comics book though, what about the likeness of Zendaya? We didn't touch on that.
We'll be getting into that. So that would be moving us into another category under intellectual property or adjacent called the right of publicity. And we'll get into that very shortly. But right now with the AI-generated components is,
My question is back to that computer that guy created,
Mhm.
that created artwork, and he didn't get a copyright. But why not? If he created that robot, he should have gotten copyright or something.
okay, so that might be touching into a slightly different category. So we're talking about the artworks that are being generated, and the artwork in itself would have no copyright. However, he may have some kind of a patent to the machine that he's created.
Right.
Now, that is a different form of intellectual property, which discusses inventions.
Right.
But there are also a lot of things which aren't protected, like algorithms and code. So it's important to note a couple of things, that intellectual property, form of protecting,
Invention.
form of protecting creations, can be of different kinds. You have copyright that protects visual works of art, it protects original works of authorship, and very importantly, the expression of something. You have trademarks that protect the name, that protect the logo, different. You have patents which protect inventions, discoveries, so forth. And then you have, you even have plant varieties which protect something else. And then you have the right of publicity, which looks into the use of somebody's image for a commercial purpose, which we'll talk about soon. Okay, here, and then there.
So I was going to say that would be a patent for the machine that he created.
Mhm.
But within that patent, could you then protect the algorithms you used?
Likely not. It likely won't be protected. Right now, all that we are able to see and understand is patent, different form of law. Copyright, different form of law.
Right.
Copyright is never going to protect an algorithm or anything of the sort.
Mhm.
Copyright, maybe the most it can do is protect short phrases, and the most it can do is protect like a series of hashtags. But even then, we're infringing on like a bit of a trademark zone. So it likely won't protect it, and Baylor will likely not receive protection for the work that he's done, but he has also appealed that.
Is that because it's not human? Is that what you were getting to way back?
Yes.
It's not human, the
Not
machine,
human, not.
and it's not expressing and creating, but it is creating, but it's not creating on its own. I don't know, it's so.
Exactly. So anything which is produced mechanically
Okay.
or automatically or by mere mechanical reproduction without that human component, immediate no. So the fact that this AI entity, this creative machine generated it, just the mere fact that it wasn't human generated devoids it of any copyright. Yeah.
I just want to know, if she doesn't copyright that art, can that be used on tote bags
Yeah.
and mugs and, she has no, if it's not copyrighted?
If she doesn't copyright this, and if you use this image exactly like this, you would be liable for infringement.
Okay.
So this artwork as a whole is protected under copyright. And if you take the fact that I'm reproducing it over here, by the way, in this PowerPoint, that's infringement. And I have likely a fair use defense because I'm using this for educational purposes.
Okay.
But if you're going to a theater, if you're going to any place, if you're watching a TV show in your room, and if you take a photo and you upload it on Instagram, infringement. Everything is infringement. And you have an affirmative defense known as fair use, which means that you have to be sued and taken to court in order to invoke fair use, stating that, hey, this is infringement, I know, but it's for personal reasons. There's a 4-factor test, which we'll get into shortly, that deals with whether the work was transformative, whether the original work you're copying from, whether that is copyright protected, whether it's fiction, whether it's nonfiction. Then you'll be looking at how much, what is the amount of work that you've taken, and how substantial is that, whether it's the heart of the work or whether it's the full book or something that you've copied. And the 4th factor is whether it serves as a substitute in the market, whether it displaces the original artwork or the original creation, and if it's creating a derivative of some sorts. So that's a whole other topic, which we'll get into very soon, about how fair use can be a defense for certain infringement. But all this to say, the fact that I've reproduced this here, infringement. The fact that I've reproduced it there, not infringement. I can do whatever I want with these AI images, but not for Colleen's work. Yes?
How did you find those images?
These images?
Yeah.
I spoke with Colleen. We have an interview with her on the Center for Art Law, and that's how I learned about her work, and she shared with me the process, the original images, and very importantly, her actual work. And that's why they're also very high quality, and I have the license to reproduce these and use them for educational purposes. But if I start printing them on tote bags, she'd be very upset too. All right, so I think we'll take a little bit of a break now, and then we'll come into terms of use, and just as a little primer of what we're going to see, we'll discuss fair use, we'll discuss infringement, and when you're actually using these platforms, what are you agreeing to? So all of that will come soon. And as a recap, now we know what copyright is, we know what artificial intelligence is, and we are learning that anything generated by AI, not copyright protected, selection and arrangement can be protected based on the extent of human collaboration. We also have discussed a lot of cases, a lot of registrations, and a lot of issues that are slowly coming up with just artists trying to use AI, seeing how they can collaborate, and whatever they create, is it up for protection? Do they have narrow protection over it? Is it not protected at all? And you can see that it differs on a case-by-case basis. So that is where we are at this stage. And now we're going to move into something a little different, because you have an idea of what these issues are and the fact that works are being created with AI, and we're yet to see who owns what, and disclosure requirements are really important in that entire process to know who, which human creator worked on something and what the AI generated components were. Now we are moving into the actual platforms. And as I mentioned, there are so many different types of platforms that you have been using, that I have been testing out, whether very simply it's OpenAI's ChatGPT, which is one of the biggest companies at the moment and one of the biggest platforms. They also have an image generation platform, which is now combined with ChatGPT, known as DALL-E. And right now, DALL-E 3 is what is operating on GPT-4 and GPT-5. So what this all means is that you can create images directly in this platform. And very similarly, if you are on social media, and if you're using Instagram, now you have Meta AI, which is incorporated into Instagram too, and you have a chat function where you can use Llama AI, which is what I had originally used for those 2 images, to create artwork as well. And the reason why I am saying all of this and talking about how many different platforms there are is because if you're using any of them, you are agreeing to a certain set of terms and conditions. Now, to put this more generally, for any platform that you sign up for, taking AI out of it for a second, whether it's Facebook, whether it's WhatsApp, whether it is TikTok, whether it's Instagram, you are signing what is known as a click wrap agreement. This click wrap agreement means usually that there are tons of tiny little terms and conditions. You don't really know what they're saying. You're quickly scrolling through and saying, yes, I agree. And that is actually the only way that you're allowed to use the application. If you don't agree to the terms of use, if you don't agree to the terms of agreement, you're not going to be allowed to proceed to the next stage. So a lot of times people just click agree so that they're allowed to use whichever platform they're using. Now, this is important because there are so many different types of companies, there's so many AI platforms, and each of them have their own set of terms of use and terms of agreement. And even when you think they're slightly similar, they are not, and they can be very, very different. I want to be a little general about this before we really go into what the AI platforms are saying. For example, when you are on Instagram, right? And you are interacting with other people's posts or you're posting your own photos, you actually have granted Instagram a worldwide, irrevocable, non-exclusive license to use your images and anything that you're posting. Simply what that means, if you have a post, if you have a reel that becomes viral and gains a lot of attention, Instagram can use that for pretty much anything, but it's usually going to be used for advertisements. And you may not get anything out of that. It's not a collaboration, it's not something that you're going to be paid for. They can likely use it because you've agreed to this license specifically with Instagram. A lot of times, artists come up to me and they have asked me that, oh, but I posted this on social media, so now it's in the public. No. Just because something is on social media, just because something is accessible to the public, does not mean that it's devoid of copyright protection. It exists in all sense. If you have a photograph and you've uploaded it on social media, you still have copyright to the photograph. It's what we were talking about earlier, that sometimes you grant a license to another entity. You're giving ownership to somebody else as well. Copyright has that bundle of exclusive rights, right to distribute, right to own, right to recreate, right to create derivative works. And sometimes you give one stick to another entity, saying this is all mine, but I'm giving you this right to use it for so-and-so purposes. That's a licensing agreement. And it is very common on these social media platforms and a lot of other platforms to enter into some kind of a licensing agreement to allow the owner of that platform to use the work in a certain way. Now, just because you've entered into this agreement with Instagram, and maybe they can use your post to create some viral moment, if that comes to it, it doesn't mean that you're granting that license to every other user on the platform. So when somebody else is using your work, and if they are screenshotting it and posting it somewhere, that's infringement. And you have a claim against them. And usually it can be solved amicably. A lot of times people don't know that that's infringement. They don't realize that, oh, but I'm just sharing this here. I'm just forwarding it by email. And that's why a lot of these platforms now give you the option to repost. You can share to story so that it prevents people from taking screenshots and from reproducing the work in any other way. The way that you're able to include music, the way that you're able to repost somebody else's image that they have posted always attributes credit to the original owner, which is why it's really important to use the platform the way it is supposed to be used at times, mainly to avoid any infringement or any concerns. And sometimes I have been very bad about this. I'm from India, and one of the reasons I actually got into this field is because I was exhausted at how there were so many movies and TV shows that I just didn't have access to. I didn't have access to a lot of the books that I wanted to read, and I would get really worked up saying that why do I not have access to it? So it leads to pirating, it leads to downloading, and you put music at the back of like a silly little video. And now if you do that, this was many years ago, but now if you even try to do that on Instagram, it gives you a notice that use the licensed audio that you can use from the reel instead of adding in audio personally on the background. And that is how intellectual property and how social media platforms have developed just in the last 5 to 10 years, that you're able to do this in a licensed way. And the reason why I'm talking about all of this and stressing upon it is because there is a way to do it, and then there's a right way to do it. And if you enter into these licensing agreements, it's an ethical and responsible way where you're respecting the rights of the original creator, and then you're doing whatever you would like to do. So I just want to make sure everybody keeps that in mind, especially because social media is becoming very big, and always give credit and tag whoever is needed. Now, how that relates to artificial intelligence platforms in particular is because each of these platforms have their terms of use. And what we were discussing right before, that sometimes you're able to create artwork and then you recreate something that's inspired by it or very close to it. So you get full protection over the work you've created, but it is narrow protection because somebody else could see the same image and recreate something similar. So the terms of use, for example, in OpenAI, they have given a very specific clause for that, stating that the similarity of the content, because of the nature of this platform and because of the nature of artificial intelligence and machine learning, two people can create two things which are very similar. And because of that, each person has the same rights to the image as the other person has. So it kind of cancels out. It's essentially what we have been talking about, that it's in the public domain. And you'll see that a lot of the platforms do not use the term intellectual property or copyright. What they tend to state is that you are using this platform, the ownership, the rights to all of the images and so forth belong to the person who's inputting the text prompt. So they are very nicely giving me, the person who's inputting these text prompts, all the rights in the work, but very carefully avoiding intellectual property and not stating that you have copyright in it. They're stating you have all rights and interests that you can have in this work. And that's important because that is kind of what allows all of us to create on these platforms. And if we didn't have that, who would these rights belong to? They would belong to the AI company, and the AI companies don't really want them. What will they do with that? They want to increase their subscription so people are using their platforms. Now, all of this background information to tell you what these terms of use are and what they state, they give you all of the rights and interests to the artwork that you're generating. They are saying that the person who's inputting the text prompt, they are the rights holder. And if somebody generates a work which is very similar to yours, then they have ownership over those too. So I can create all of those images that you see, print them on a tote bag, canvas, and sell them, but so can you. And a lot of times, people think that, oh my God, this is a very new, very novel concept. What is artificial intelligence doing? But this is very similar to photography. This is very traditional issues that we are seeing, but just applying them to artificial intelligence. Two people can take the same photograph of the same thing, and it can look identical. It can be right about the same pose. But both photographers have copyright in their individual works to the extent that it is an original creation. It's just that it's rather very narrow copyright, meaning that nobody can directly take your entire photograph and reproduce it, but they can pretty much have something that looks exactly the same if they did it in their own way. So these are interesting issues, but they are not new issues. And right now we're just seeing how they're being applied to AI entities and what that looks like. So here are a few examples of what some of the AI platforms are stating in their terms of use about who has the ownership rights, what kind of licensing agreement do you have with this AI entity. And we have seen a couple of different platforms already where you're able to input your text prompt and you're able to create an image, but also you are able to upload your own sketch. You are able to upload your own images. People are uploading screenshots, they're asking AI to analyze them, they're uploading very personal, very private moments, asking for some kind of a analysis. A lot of selfies are being uploaded. What is happening to all of this information? And where is it being stored? How is it being stored? It's concerning because all of the platforms can be very different, and a lot of times you don't know, but when you have agreed to use the platform, sometimes you are, depending on the platform, you are also allowing them to further train the AI platform on your prompts and all the information you're putting in. which is why in just the last few weeks, people's medical records have been pulled out from ChatGPT. And somebody was able to see something which they should not have seen just because all of this information has been uploaded and confidential information is also being regurgitated. You also have a lot of legal issues in terms of actual legal briefs and cases being asked for, and the work that is being reproduced could have been confidential client information. So this is just a little look at how concerning it is with just the information you're putting in. One of the biggest lawsuits right now is New York Times versus OpenAI. And the reason why I'm bringing this up, OpenAI is the company that owns ChatGPT. And right now they are being sued left, right, and center. And they can have all of the chats that they have, you can delete them, you can archive them, you can do what you want. But if subpoenaed, they can pull out any of this. And they can use anything that they want as part of evidence and discovery.
Is there a difference if you sign in or not? Because I use it for like travel, like looking for airlines and things like that. But I never sign in. So is whatever I'm putting in, it vanishes then, correct?
No.
No.
Any information, whether you're signed in, whether it's associated with an email account, that information is being used. It might be even a little more concerning because at least when you have an account, you go to the settings and you can opt out. You can opt out of training and you can opt out of a whole bunch of things which they legally have to provide there. It's just that sometimes it's not known to people that, oh my God, this is being trained on whatever I'm saying at this instance. So it's sometimes better to go in and to actually go to the settings and make sure that training is off and opt out is, you have done all of that. But anything that's being put in, just would not trust that platform completely at this moment. With regard to images and photos that you're putting in, it's even more concerning, and we'll get to that very shortly when we talk about data scraping. And it can be harmless to think that, oh, I really, really like this artist's work, and I want to create something that's kind of similar to it, but in my own style. So you share with ChatGPT, or you share with a platform in artist's work, a younger artist, an emerging artist. And now that is being used and is being trained, and it's being associated with the text prompts you're putting in. So you're able to create more in the style of certain artists who maybe didn't want ChatGPT and AI to reproduce the works the way that it's doing. I will also say that when you are putting in your own images, your own selfies, there have been a lot of apps, and I'll show you one of them. One was called Lensa AI, and it got a huge amount of popularity because people could now create magical avatars of themselves. And it was reimagining you as different characters. And people loved it. And it was like, oh my God, a little narcissistic, but it was fun. And you're like, let me see how I look like in this way. And it was enjoyable. But you will see that Lensa AI changed their terms of use about 20 to 30 times during that state. The original terms of use had no information about image and data privacy. And in the updated terms of use, they said that it can be used for training, it can be used for pretty much everything. And then in an updated one, they said, okay, it's not going to be used for training. And it was very concerning because in numerous circumstances, whatever you're putting in, it could wind up on any website. There have been a lot of concerns with deep fakes, but the fact that you're also putting your own images and then creating kind of deep fakes of yourself and then sharing it, you are training artificial intelligence to create in different ways. I'll also say there are a lot of other concerning issues with the app that we won't get into. There was bias, there was a lot of prompts for nudity when it was not needed, and there were tons of other issues, but we'll stick to like the copyright concerns of all of this. It was just, you are continuously training these applications. And what all of these terms of use essentially state is that you are the owners of these works, you have all of the rights to it, but you are granting the AI platforms a license as well, just as you are on social media. And they can do pretty much whatever they want with it.
That's right.
Unless you... Yeah, unless you explicitly opt out, and that is not always done, and sometimes there's no option to opt out.
Yeah.
Now, the best case scenario would be if you're actually allowed to opt in. But data scraping has completely taken over, and we've reached such a stage where it's already out there. And right now we're focusing on some of the biggest companies and the biggest platforms, OpenAI, Stability AI, Midjourney. There are thousands of smaller AI platforms that are using the same GPT to run it. And what is the difference? These bigger platforms have been shamed, and they have been boycotted, and they have seriously been put to shame on social media to have different terms of use and to protect artist rights. So they have now implemented a bunch of different prohibitive blocks where you can no longer create in the style of a living artist. So that if you're not able to create in the style of a living artist, it would protect the work and protect the original artist's work from being showcased. Now, the reason why that is such an issue, if you're trying to recreate in the style of Klimt, or if you're trying to just create inspired by somebody else's work and somebody else's painting, you could create something that you really like, but the work is continuously going to be out there. And even if the bigger platforms have now prohibited it, smaller platforms can still do it. Once it's out there, it's pretty much out there. Mm-hmm.
Let's say you're creating something on one of these platforms, ChatGPT, and you're like creating whatever, a work of art or an app, whatever, that's something.
Mm-hmm.
And you're like, I'm opting out of you being a license, having any licensing. Like, is there language you could literally put and paste in there?
Do you mean for to send to who or
To
what?
ChatGPT, like
Yeah, to when you're creating
in the app itself, like while you're creating it, and saying
Yeah.
like, you have no rights to this.
Well, I wish, but this is
Yeah,
this would be the agreement with OpenAI.
got it.
Yeah. So ChatGPT, and fortunately, does not have a mind of its own, and you can create anything, any kind of agreement or any license with ChatGPT.
But you've already opted in.
Yeah.
Okay.
So you have to go to ChatGPT, look at the settings, look at what OpenAI is providing, look at the terms of use of OpenAI, or look at the terms of whichever platform you're using, and see if you have an option to opt out. Mm-hmm. And hopefully you are able to opt out at that time from at least training, but it is difficult at this stage. And that is what we are seeing with a whole bunch of artists as well. And I wanted to mention the work of one particular artist, Kelly McKernan. And she was part of a class action lawsuit against OpenAI, Midjourney, Stability AI. And I had the pleasure of speaking with her. She spoke at one of the Center for Art Law's conferences. And she is a digital artist, amazing, incredible, creates very, very cool work. And she had reached out, we were having a discussion, and she had noted that she was so excited, this was back in 2022, to collaborate with artificial intelligence. She said that I'm really looking forward to DALL-E, which was OpenAI's very first image generation platform, DALL-E 2, and she was really looking forward to it. She wanted to collaborate and see how she could scale her work. And then one day on Instagram, somebody tagged her in a post saying, hey, I really love your artwork here. And it wasn't hers. It looked exactly like her work. It looked like a series she had been working on. It looked like a series she had in her mind. And she was shocked to see that it was just out there. And this work looked so similar to hers that people she knew were like, oh, this is amazing. And there are a lot of issues with this statement, right? One, you're able to create in the style of another artist. And that in itself is a little concerning because this could take commission work. If you are no longer paying one artist to create and you can have the way that they create works mass generated, that is at an absolute fraction of the cost, like maybe 50 cents, you'd be able to get 4 to 10 images at least, or even for free in a lot of circumstances. What are you competing with? Who are you competing with? And if you're a younger artist, an emerging artist, or a re-emerging artist, and you're trying to get your work out there, and if somebody likes it and they start recreating in your style and other people don't know who you are at that point, and you're just now part of the training system. So while Kelly McKernan was speaking at the conference, one of my friends was attending, and he sat in front, and as she was talking about this, he created 8 artworks in the style of Kelly McKernan in about 10 seconds.
Wow.
And I was just like, you're not allowed to do that. And he said, but I did it, and other people are able to do it, and that's the biggest concern.
Right.
So she really tried to opt out. It was very difficult to. She found out that her work had been used for training purposes by using a website called haveibeentrained.com. And haveibeentrained.com has actually been used by the courts, and they have accepted it as evidence, which is great, that you can use this website to show that training has happened and your work has been fed into these systems and it's being regurgitated. Now, Kelly McKernan, as I mentioned, was part of a class action lawsuit along with Sarah Anderson and Kelly Oritz, who are other artists. But Kelly McKernan's artwork was not copyright registered. So her claims were dismissed. And she could file again, but she lost out on statutory damages. The case is still ongoing, but that shows you copyright law. And what we discussed earlier is that you have copyright regardless, but sometimes the frustration is that what is it doing if you can't file a lawsuit or claim any damages if your work isn't registered? So before filing a lawsuit, before you ever go to court, and I hope it never comes to that, make sure that your work is copyright registered. And I think Kelly McKernan's example is just a really good one to show a number of things. And we'll discuss her once again in a little while, just to showcase what happens when the law is not working in your favor. What can you do beyond the law to protect your work? So keep that in mind, keep these artworks in mind, and we'll discuss that very soon.
Privately, can you sue privately?
You can, but what if we try to avoid litigation altogether and protect your work without having to go to court? So there are a couple of tools that I will discuss very shortly, but I didn't get a question.
Is there a time factor, like can you register your copyright after your image has been stolen?
Yes, so after your image has been stolen, you can register your work in terms of, oh, you've seen somebody's work and it looks similar to yours, immediately register. Just before you file the lawsuit, make sure that it's registered. And once again, you can file after as well. It's just that you lose statutory damages. And statutory damages under the Copyright Act are able to claim a certain amount of damages for infringement, which is great. But if you lose statutory damages, then you have to prove something known as actual damages. And actual damages can be really difficult because you have to find every instance of infringement and have to prove that this is the cost so-and-so.
7 years.
So that is, yeah. There was one more question?
Yeah, and just as a catch-up on copyright for works of art, is it possible to copyright like an anthology or like a collection?
Yes.
Just to get caught up on whatever's not copyrighted yet?
Yeah, so it is, once again, interesting and a little nuanced. You can copyright a compilation, and that is a selection and arrangement of works, but that's exactly what it protects, the selection and arrangement.
Okay.
So it's a little, I don't really get it sometimes because you ultimately have to copyright every individual piece if you want it protected, or you can copyright it as a book, as a compilation. But yeah, a lot of times catalogs is a good example of that. It's easy to copyright and you don't want somebody to have the same curation as you have, but it doesn't work for a lot of things, like a photography book. That won't be very helpful.
How difficult is it to register your work to get a copyright?
So it's not difficult to register at all, and just so you know, you can register your work without the help of an attorney. There are a lot of, it can be a little intimidating the first time, but it can be done. The Copyright Office, which is a federal body in the United States, they have really great resources online where you can actually see how to register. The Center for Art Law, we have a webinar exactly on this, on registering a copyright and filing an infringement notice, which once again you can do without a copyright attorney, without any attorney. It's just that there's a cost consideration as well, which is usually what inhibits a lot of people, including artists, to not register all of their works, because for each work you're paying anywhere between $35 to $85. So it can add up. So if you have a few works, then you are good. But if you have a large collection and if you want to copyright everything, the costs really do add up. But it's a very good question, because a lot of times people do not know that you don't need an attorney to register copyright. And a lot of the artists that we've seen, Colleen Hoffenbacher, for example, with her Region and Florigen, she copyrighted those herself. She didn't need an attorney for it. So it's very doable. First time when you fill out the form can be a little scary, but then after that, you're all set and you're able to register.
Just to clarify that, so let's say you had a book of photographs and you registered your book instead of the individual 300 photographs. Each photograph is not copyrighted.
Each photograph is not copyright
Just the
protected.
book.
The selection and arrangement and the book as a compilation is protected. Yeah. Now we are coming to something. This is also an article that we published, and I will share that maybe with you, Dorothy, because this is a really stressful topic at times, and it has come up in conversation already many times. When you create in the style of, and when you're using somebody else's image, somebody else's likeness, or you're just using the way somebody else creates in order to have your own creation, to have your own artwork. So what does that mean, and why are we talking about it so independently, right? Well, in the style of is not protected under copyright. So that is something that you have to keep in mind. The reason why this has become such a big issue and it's such a growing concern is because creating in the style of an artist is not something that's necessarily protected. We talked about the US Constitution and we talked about the copyright clause. We talked about the IP clause. We discussed that the reason why certain things are granted protection, not granted protection, is so that people don't monopolize certain ideas and you're allowed to create and build upon creative works. Now, if you start copywriting an entire style, an entire genre, if you're trying to copyright oil paintings, if you're trying to copyright animation studios, then you are blocking a whole bunch of creative people from doing what they may do best. And that is why style is something that is not granted protection unless it's extremely, extremely, extremely distinctive, and it's usually not enough for it to be protected. One of the biggest examples that I can talk about was creating in the style of Studio Ghibli, and that became a very big concern, and everybody was very upset about it, saying, hey, you can't do that, isn't this against IP, and isn't it against copyright, how are you allowed to do this? And very simply put, style is something that does not receive protection under copyright law. So if you are creating in the style of Van Gogh, if you are creating in the style of Monet, if you are creating in the style of Kelly McKernan, that's something that you can technically do. A discussion on artificial intelligence at this stage cannot be purely legal. It has to be ethical and it has to have a few moral considerations into place, just because the law is not able to catch up with the developments in artificial intelligence. We're seeing poetry cameras, we're seeing lawsuits left, right, and center. I wish I could give you precedents. I cannot give you any precedents. We are still hearing and we're still waiting. We're in the process of submitting an amicus brief for one of the cases, and it is just a waiting game. And in the meanwhile, how much are these platforms developing? How much more are you able to do with them and to create with them by the time we hear back? So creating in the style of is something which does not receive any protection. Now, we are also going to move into something called the right of publicity. Now, this was something that has come up a couple of times, right? That if you're using somebody else's face, somebody else's likeness, if you're using the voice of somebody else to create something, then what happens? Are you allowed to do that? So now we pivot a little bit from copyright to something known as the right of publicity. And the right of publicity basically protects somebody's image and somebody's likeness to be used if you are in a state that has the right of publicity and if it's used for a commercial purpose. Now, I will talk about another example. So we are now moving a little bit into right of publicity, music, and artificial intelligence. And what happens if you're taking the voice of somebody else and you're imposing it onto maybe the voice of somebody you already know? I thought this would be a great example. So creating in the style of Harry Styles. And Taylor Swift has a song called Style, and I'm going to play it for you. And what one creator did is that this requires a little bit of Taylor Swift lore. So Taylor Swift was dating Harry Styles, and this song came out. And what if Harry Styles sung one of the stanzas or one of the paragraphs on Taylor Swift's song? How would that sound? How would that look like? So they created that using so you can hear Harry Styles layered over.
Every day they do this. DJs.
So that gives you a little bit of insight into using somebody's voice and putting it into a song by another artist. And this is a little nuanced because one, you are changing an artist's original song, you're changing their original creative work, then you are taking somebody else's likeness, somebody else's voice, and adding onto it, and essentially creating a derivative, some kind of a remix using artificial intelligence. So you can see that there are many different layers on what is happening over here. One, would the song that you're creating with this Harry Styles remix actually qualify for copyright protection? Likely not, because a lot of this has been generated purely by artificial intelligence. The creator who made this, and it's really interesting because this was posted in 2023, YouTube has a very strong infringement policy, especially Taylor Swift, it can be very litigious, but it has been up since then, and now we're in 2025. And you have posted this song, you have included somebody else's voice on it, it likely does not receive copyright protection, but what happens to Harry Styles' voice? Are you allowed to take somebody's voice like that and use it? Probably not, right? You would think you're not able to, but the right of publicity, for example, is a right that is state dependent, whether you're in New York, whether you're in California, then you have something known as the right of publicity, and it needs to have some kind of a commercial gain. So if you're not earning anything commercially from this, you likely don't even have that right of publicity claim against the person who is using the voice, which can make it even more concerning. And finally, you've added this on and you've changed the original meaning of a Taylor Swift song. Would Taylor Swift like her ex to be included on her song?
Maybe.
We don't know. But this goes to show that you also have something known as moral rights. And moral rights is when the meaning of your work has changed. Now, in the United States, you have something known as VARA, the Visual Artists' Rights Act, and that discusses moral rights. It talks about the rights of a creator, the right of attribution, the right of paternity, and the right against destruction of your work. Essentially, if somebody is coming and mutilating or destroying your work, then you would have a right under this act. Now, in the US, as you can tell by the name of the act, Visual Artists' Rights Act, 1, it applies to visual art, and 2, under the act, only works of recognized stature can receive moral rights. It's important to note that this is different in other countries. In the UK and in India, for example, moral rights are practiced a lot more vehemently. You don't have so many restrictions when the work of an artist is destroyed. But in the US, there are a lot of terms and conditions. And because of that, over here, likely the work that is being produced, the new song is probably not copyright protected. Does Harry Styles have some right against his use of the likeness and his voice in the song, he might if they are earning some kind of money from it, and if this action is New York or California, for example, based. And finally, is this a derivative work? If this is a derivative work, then we have our answer here, because to create a derivative work, you need a license. Otherwise, you need to be the copyright holder. And if you don't have a license, and if you don't have the rights, the exclusive bundle that we talked about earlier, then you are 100% infringing. This is likely going to be considered a derivative work. It's impressive to know that that this is actually still up and available and still on YouTube. But for anything of this sort, it's important to have some kind of a license. And now you have so many artificial intelligence platforms. We were just discussing, you have a video generation platform called Sora, and you're able to, I'm not sure if you've seen these videos, they're once again very disturbing, but you can take a photo of yourself and it analyzes your face, and then you can get this face to do anything. You can have a conversation with another person. The more people you invite on the platform, they can also have their face scanned in, and you can have a whole group video on something. And sometimes they come out really weird and really disturbing. Sometimes they look very spot on. So it is strange, and it is scary to see how people are able to do this. And along with Sora, you have Suno, which is another music generation platform. And we've been testing a lot of things out. And some of these songs that come out I would listen to them. If I didn't know they were artificial intelligence, I think they sound so good. They have that earworm. You would, if it's in the style that you like, it's very easy to replicate it and to play it. If I didn't know that so many of these were AI generated, they would likely be on my list. So it is very concerning to see what is being done and whether there's any infringement action, whether it's fair use, whether it's transformative. It's difficult to say at this point, but the fact that you are generating all of these works, you're generating these songs, not protected by copyright because it's AI generated. Now, what if you take lyrics, or you write lyrics and then put it into this platform and be like, generate a song based on the lyrics that I've written? The likely consequence would be the overall composition probably wouldn't be protected, but your lyrics and your words might be, because it's human generated. So you can see that there are lots of combinations on how this could work and what makes sense and how people are creating and building upon other works. I think a lot of publishers, a lot of music producers are using these platforms for certain sounds, and depending upon the extent that you are using, then you may have some kind of a copyright claim or not.
I have a question, because you see these DJs, that do the mixing, and they take pieces from everything, and then they generate, they have all the people dancing.
Yeah.
They're using it for publicity, what would you say, or for entertainment? And then if somebody's bootlegging that outside, and then they're on these, I don't know if they're on chat or whatever, but they just doing the DJ all day, and they're grabbing other people's music. And then you're saying if they selling something, like, because I heard somebody, they use Jimi Hendrix, it's over 70 years, they'll use only a certain amount of lines, they're legally, and then they're promoting these things, and the people are dead, like Freddie Mercury, and they got his voice going, and you're like, what, that's Freddie Mercury, and he's selling, pillows or whatever, I don't know.
Absolutely.
And that's legal, right?
A lot of celebrities, they might have this right of publicity claim against them. Scarlett Johansson is somebody, for example, who was very upset that her face and her...
She's from here. She's from the Hudson Valley.
Oh, I didn't know that.
Yeah, she's from up here, Tuxedo Park.
Yeah, but she was very upset that her work, her face was being used in ads that she wasn't endorsing. And I think that is the biggest place where celebrities would be able to get some kind of an action at this stage, because it's false endorsement and it's some commercial gain for another entity. So that's probably where we'll see the most of it. It's hard to say with DJs and with the way AI is being used. A lot of it, people are not even copyright protecting it. They don't seem to care. It's advertising, it's promotion. They're putting it up and gaining some kind of traction. And people are very much allowed to do that. I just wanted to share like some, if you write in the style of Adele on ChatGPT, it generated, it gave me like what her voice sounds like, and then it tried to generate a song in her style. Now I tried out a whole bunch of things, and it was interesting to see what worked and what didn't work. When I once tried out with this, I can't remember who it was some song by the 1975, and I was trying to see whether I could create something in a similar style, and it said, no, I can't do that because that could be infringing. So then I asked, can you do it in a way that's not infringing? And it said, yes, here you go. And it produced everything. And it just incorporated what you see over here, that it took the description and the overarching theme, or what that song would look like, or what that book or whatever would look like, and then it bypassed its own infringement blocks and was able to create, because you're not using a specific name, now you're just describing a specific person without using the name. But I thought it was interesting, when I asked for these lyrics, it immediately produced them. But when I asked for an artwork, this was its response. It said that I can certainly create artwork inspired by so-and-so artist, but you need to describe what it is. To stay within copyright and ethical guidelines, I can't directly copy or replicate her exact works. So this goes to show that it has now understood that in the style of is not protected. So as long as you're not using the name, you can kind of create something that's similar without replicating the works.
But did it understand it, or did Catherine, or whatever her name is, did she sue or something?
This was a completely random artist. I was just testing out a couple of names from a whole bunch of the artists I really love to see whose work was in, whose isn't. So I checked, have I been trained? And I used her name very carefully and specifically to see if anything would be generated. But it could be if I described what it is. And a lot of times, I didn't want to do it in this case, but a lot of times what people would do is upload a photo and be like, oh, can you generate something in the style of this? And kind of get away with it. But I thought it was really interesting to see the distinction and difference between the forms of art in terms of lyrics and then in terms of visual art. How for the lyrics, it didn't stop me at all. It just generated them. But here they said, hey, copyright guidelines. So it's a bit of discrimination between which forms of art deserve some kind of protection or some kind of consideration.
Have you seen the film The Congress?
I have not.
Okay, so it's like in terms of like likeness and publicity, it was a 2013 film, like very ahead of its time, where Robin Wright plays herself. Mm-hmm. And she is giving over the rights of her likeness to a big studio. It's Miramax, like it's, Miramax MGM. And she essentially becomes an avatar of herself. Mm-hmm. It's amazing, so they own her likeness. Yeah. And she like fades away, and they digitize her in her her prime, essentially. And then she just fades away. The studio owns her likeness in perpetuity forever. They then generate all these movies about her, of her. And, like Tom Cruise, like all the A-list stars. It's incredible.
What's the name of it?
It's called The Congress. Ari Folman, the guy who did Waltz to Bashir, did it, but I think it's really like...
That sounds incredible.
It's incredible.
Yeah.
It's called The Congress.
It reminds me of a whole bunch of cases where...
Yeah, it's what's like,
video games, a lot of times developers are sued because they think that certain celebrities' likeness has been used in the video games. Paris Hilton had sued. She was quite upset because it was a blonde person that was used in a video game. Yeah. But courts have made a distinction between when the likeness is actually used. And I think it was the Wheel of Fortune, the actress Vanna White. I think that was a big case where her likeness was used for an advertisement, and it was once again being used continuously, and she was able to win that case.
Like how, right? How
yeah. So it's crazy because that's something you can do. You can, and people do it, especially influencers, celebrities, and there's this application. I don't want to advocate for any AI apps, but there is this application called 11 Reader, and they do have licensed voices of a whole bunch of authors and celebrities across the world, and you can enter text and you can create podcasts in the voice that you would like. Apart from having an American accent or a British accent or an Australian accent, you can also do it in certain style. And 11 Reader is interesting. And I would say, if you're curious about it, it's worth looking at. I wanted to mention, and once again, the same exhibit that I went to, the Human Assisted AI Art, there's one artist, Greg Rudkowski, and there was this AI photo booth there where you go in like a classic photo booth, you take a photo, and then using artificial intelligence prompts, you can change the image. And Greg, this artist, he's very, very well known. If you Google him, his work will come up immediately. But apart from that, you'll continuously see an article where he's like, I just want to opt out of AI. I want nothing to do with it, and I'm not able to opt out. And I found it so shocking because I was at this random, really, really random small exhibit in Brooklyn, and his name was there, and to create in the style of. It was also really weird because I was with a girl, but they made her into this Chinese, old ancient person. And it was really strange to see a lot of these prompts and how they, it was a weird experience, but more than anything, it was to see a lot of these prompts using his name continuously after trying to advocate so strongly for himself to no longer be included in these type of things. So like I said, when you are working with bigger platforms, sometimes it's better just because they have certain blocks in place. When you start working with smaller AI organizations, companies, platforms, it's already out there, and there's really no limit and no prohibitions. I wanted to mention very quickly a couple of other things. When you had Lensa AI and had all of these magic avatars being produced, in the corner and in different areas of the artwork, you could see that there was a mangled signature of sorts. It was always on the bottom right or top left or something of that sort. And a lot of people are like, this is how you know that AI is taking artists' work because it's recreating their signatures. But another side of people said that, oh, but AI is now learning that especially for portraits, there's always a signature. So it's creating its own version of what a signature would be. And I just thought that those are two very interesting arguments that are coming up based on the images that were being generated.
So you're saying that AI is creating now its own signature?
It
or
could
by
be.
itself?
It is.
That's the scary part.
It is learning that that is what portraits usually have, and maybe, apart from taking apart different signatures of actual artists, it's now automatically putting in a signature, knowing that, oh, this is how I can show that it's an authentic portrait. Another really concerning example was this, actually was just this Reddit mod, and Ben Moran, who's also a digital artist, very proud of all of the work that he's done, he was part of this community, this forum, and they would upload all of their artwork and they would get comments on it, and then one day he was banned from it because the moderator stated that your work is AI generated. And he said that, no, I can show the PSD files, I can show the original creations, it's not AI generated, I created these. And then this moderator said that, well, no one is going to believe when you say that it's not AI, and AI can do better in seconds what might take you hours. Sorry, it's the way of the world. This was his response, and he wasn't allowed back into this forum, and it was really unfortunate because this forum was created to protect human artists against AI, and his work was being mistaken for AI-generated artwork. And it's a huge issue that we're just generally seeing in terms of digital art especially, that artists who are digital artists and have been creating for years and years using these softwares and platforms, now it's very easy for AI to replicate those. brings us to whether is this fair use or whether it is infringement. And we are still trying to answer that. I just wanted to reiterate that whenever we're discussing fair use or infringement, as a copyright holder, these are the exclusive rights that you have to make copies of the work, to create derivatives, to distribute, to perform the work. And if anybody does any of these things with your work, that is infringement. So I mentioned this case a little while ago briefly because it's a very big, very concerning case, New York Times versus OpenAI. And New York Times, that you're probably familiar with, they sued OpenAI, which is this large AI company. And what they were suing for was that OpenAI had taken all of the newspapers, the articles, the how-to guides, and basically everything that New York Times had published, and they had put it into their training system to train their LLM, to train their algorithm to learn everything that New York Times had published. And it's really interesting, this case, because there were many issues surrounding it. First, OpenAI's response was like, no, you hacked into our system, and that's why you think that that's happening, and it's regurgitating New York Times' articles. So they tried to say that this is not something that is normal, and you've hacked it in some way that it's showing that you were able to verbatim reproduce New York Times' articles. But New York Times had a whole appendix attached in their complaint when they filed a lawsuit showing verbatim language that ChatGPT was absolutely regurgitating. It was word to word from their articles. There was no change at all to it. And this case is still ongoing, but OpenAI's argument is that this is transformative, that the work that it's doing, it's one, you're not able to get verbatim language, whatever they did, you hacked the system and that's how you got it. But even if so, the way that information and images are being processed is very different from the original intent of the images and the information itself. So they are trying to argue for something that it is inherently transformative because artificial intelligence is creating it. There's a bit of distinction that I would like to make, it's not in this case, but in general, between generative AI, which is a lot of what we've been discussing, meaning that AI is generating and creating something new, versus assistive AI, where you're making edits or you're using it as a legal research tool. But regardless of either of these types of artificial intelligence, whether it's assistive, whether it's generative, if you are scraping the internet in order to find images to train it, the fact that you are reproducing, scraping the internet and copying this, isn't that direct infringement in the first instance, regardless of what the final output is? Any act where you are copying work, as I mentioned, taking a photo of this, infringement. Sharing a news article on an email, infringement. It's whether it's going to be fair use or not. So they're trying to argue that it is a blanket fair use defense in some sort of a way. Right now, it hasn't progressed much. It's still very procedural, but OpenAI tried to basically bury New York Times with discovery, stating that you have to show that all of the works that you are telling us that we infringed are copyright protected. So they were asking for all the registrations, but the court said no, that is not what's going to happen. And we are just waiting to hear what this case is. And before I discuss some more of the issues from this, I also want to mention the Thomson Reuters versus Ross Intelligence case. This is also one of the big cases, and it's got to do with Thomson Reuters. And if you are familiar with Westlaw,
Actually, what my question is about those cases where lawyers have been using AI and there's been hallucinations and they're throwing in cases to support arguments that didn't really exist, and so forth. Is that generative AI that lawyers are using as opposed to assistive?
I would say that is generative because so to get to this case, this has got to do with kind of indexing. And Westlaw, which is a legal research platform, what they usually do is that all of these heavy legal opinions that you read, these cases, they have a summary for it, and they create a little head note which is copyright protected, and they state that this head note, it has all of the important bits and information about the case and a summary, and it's curated and it's compiled very carefully. And Ross Intelligence, which is now defunct, by the way, it doesn't work, and they had to use all of their savings to continue with this case. They had a tool, and this tool was essentially the same thing of what Westlaw provides about case summaries. And they had asked a third party known as Legalese to take these cases, and they said, hey, you can take the cases, but make sure you don't copy anything verbatim. So despite that instruction, apparently some cases were allegedly copied verbatim, and they were included in this, in Legalese's summarizing of cases and of all of the summaries of the cases. Now, why this was an issue is because mainly you have Westlaw, which is a service, and you're getting case summaries from it. Then you have Ross Intelligence providing a service with the exact same case summaries and at a cheaper cost. So that looks like it's a bit of a market substitution. It looks like you're trying to eat into the very same market that Westlaw was doing while copying the exact same case summaries that Westlaw posted. So what the court held, the lower court in Delaware, they stated that this was not fair use, and I wish it would end over there, but now it's on interlocutory appeal, and they're trying to see whether there's some sort of a blanket fair use defense for AI-generated cases, or how such cases are going to be handled. So there's so much going on, and there's so many different nuances, especially for some of these big cases. The question that you were mentioning is a little different, because what attorneys are also doing is that they're using artificial intelligence to generate case summaries. And that's a little different from this, because they had human lawyers making the summaries based on Westlaw's case summaries. And yeah, that's why it's a little confusing. But if you have a human lawyer who is now using AI to generate case summaries, which are AI generated, and it's coming up with wrong information, wrong facts, and very importantly, wrong citations. And once again, we have been testing this out, and it's extremely concerning, especially for more recent cases and complaints. It's made up facts, it's made up parties. You'll be like, hey, could you verify this information? And it'll give you a link saying it's here. There's nothing in there.
Right.
It's just completely, there's whatever you're saying is not quoted at all in that case. And a lot of attorneys had used some of these, and they were just held in contempt by the courts, and you cannot do this.
Wow.
So you have to check your citations, you cannot use them. But I will say that there are a number of AI platforms that firms have incorporated into their practice too, for different reasons, like contract reviews, and that's more of assistive artificial intelligence than generative artificial intelligence. And as a user, while testing out all of this, as a general fact, I will say that if you are using AI and you're asking it to create something new, to create new text, I think it goes very poorly. However, if you give it the universe, if you input a certain amount of text and ask it to do something with that text, it's much better. So you can see right now the way that it's thinking is off, and you're not able to verify anything. However, if you put verified information there and ask it to do something based on that, you're likely to get a slightly better response. So the uses of AI are still very, very...
I find it varies from day to day, or even from hour to hour. I've tested it, like put in the exact same thing, and it comes up with wildly different results.
Yeah, it's just should never be used as an authority.
That's right. That's right. No judge should be AI.
Yeah, absolutely. I was going to go into some of these, but I think we're running a little out of time. But I just wanted to mention that these issues are there, and there's so many issues with fair use, infringement, copyright, authorship, and I can go on. There are also jurisdictional issues. I want to mention that what right now we discussed is so US specific, I can't even begin to tell you what's happening in other countries and how the EU is handling things, how the UK is handling things, how France is, how India is. It's been very overwhelming, but every country has kind of got their own way to look at things. And we've been talking about copyright and authorship, and I wanted to mention something because so many comparisons have been made to, can AI ever be granted authorship? What would that look like in terms of lobbying to include AI as a human author in the Copyright Act? And I wanted to mention something in India. And India is a really great, very big country, and it has a lot of religion-based activities, and it plays a very important role in people's lives. And because of that, you have laws based on religion too. You have Hindu personal law, you have Sharia law, you have Christianity, you have minority law for Buddhism. And under Hindu personal law, a deity, a statue of a god or goddess, is actually granted separate legal status. They are considered as a separate legal entity. Trust can be endowed to them. They can give testimony in court. And there was a case in 1988.
Sculpture?
A deity, yeah, like a small god or goddess, like a deity. They are granted this individual status. And there was a case where there was a Nataraja statue in South India, in Tamil Nadu, and it had gone to get a little bit of repair work done, but of course it was stolen in the process by a collector and landed up in Britain. And the state of India sued the Queen's Court, and this statue, the Nataraja statue, this dancing entity, gave testimony in court through a representative of the temple. And it stated that it wanted to go back home because they were able to trace the provenance. And they won. And this case was this statue was repatriated back to India. And just to show you how complex art law is in general, it was stuck in customs for 10 years before it was given back to the temple, after tracing its provenance and so forth. So I just want to mention that these cases, right now we're focusing on the US side of things, but you have to understand that there's a whole world out there, and a lot of comparisons can be made between, let's say, granting a state, like a deity, a status of a legal entity, and granting artificial intelligence some kind of status as well.
So you're just saying copyright is not global, it's just here in US?
So copyright is something that exists in all countries.
But each country is
Each
different.
country has different laws. So based on your jurisdiction, where you are. In fact, when I came to the US, it was also very surprising to me because the state law is so different over here. I think in India, for example, you have more of a center and you have certain laws. In the US, what I noticed is that state laws for like divorce, legacy, estate, trust, they differ so tremendously. So it's important to note that intellectual property, you have an organization called WIPO, which is based in Geneva in Switzerland. It's the World Intellectual Property Organization. And they had model laws. And a lot of countries, including India, adopted those model laws. So we have copyright, we have fair dealing, we have all of this. But it can be interpreted judicially by courts in very different ways. One of the biggest things, which I also learned, a little sidetrack, there was this case about course packs, and it's called the Delhi University photocopy case. And essentially what happened over here is that there was a photocopy guy outside of Delhi University in India, and he created these little course packs of educational materials. And this was about 50 rupees, and that's a little under $1. And just to let you know, law school in India is, for example, 5 years, and it's 10 semesters. And if you want to purchase any international books, it's about, I don't know, $3,000, $5,000 to get one, like an international book. And a lot of times what I would do in law school, I would also take photocopies of certain books, I would write my notes, and I would hand them to juniors as well. Because if I had to buy all of those textbooks for 10 semesters of law school, it is not happening. And this photocopy shop, the guy had created all of these course packs, and he sold them for like less than $1. And one of them included chapters from a book published by Cambridge Publishers. And then they sued the small Photoshop guy saying, hey, that's infringement and you are not allowed to do that. You're taking our photocopies, you're taking photocopies of our textbooks. And I was actually working on this case and it was really exciting to research on it. And there were so many things that we looked at, including fair use and fair dealing, and how there was no market for these books because nobody had bought these books because it's higher than income in people's country. So no one was purchasing them. And when it finally went to court, the Delhi High Court stated that we're not even going to look at fair use or fair dealing, which is what it's called, because this is not infringement. And the right to education, which is a constitutional and fundamental right in India, is at a higher pedestal than intellectual property laws. And I had already researched US cases, and when I came to the US and studied these, it was decided very differently in US courts, where economic incentives are much higher. But I realized that there was no right to education in the Constitution, which was also a bit of a learning experience. But it was phenomenal to see how courts can completely reinterpret certain laws based on their own jurisdiction. So you cannot compare a lot. You can do a comparative analysis, of course, of different cases and how they're handled, but today is, except for the little bits and pieces I've given, it is primarily US law. I don't have enough time to talk about trademarks. Our focus today is copyright, but there are a lot of more protections that have been in place for trademarks. I tried to use Louis Vuitton and Gucci to create some artwork, and instead of generating the names or the logos, it generated these very luxe-looking pups. And I thought that that's kind of artwork in itself, but it was really interesting that they didn't use the logos or the names, and they seem to be more cautious of trademarks than they are of copyright. I would say the way forward, I always come across like artists who are excited to collaborate, and then artists who are vehemently against the use of AI and want to boycott it. And I always say that these approaches are absolutely correct in your own mind as long as you're aware of what's happening. You need to know how AI is being used, how it is infringing or potentially harming people. You need to know how it can be beneficial, how other people in a workspace or industry may get ahead by using some certain tools. As long as you're aware of it and then you decide what you want to do with it, that is the most important thing that matters. I think AI is here to stay, though, so the way forward would be ethical and collaborative. There are a bunch of best practices that I would go into detail, but you will see that a lot of the times for tech companies now they have blocks, and you're no longer able to replicate in the style of certain artists. But for artists, watermarking your work can be really, really helpful, just because if somebody removes a watermark from your image, not just for AI, but for anything in general, you actually have another claim under Section 1212 of the Digital Millennium Copyright Act. So you have a stronger claim if you have a watermark on your artwork and if it was removed.
Like over the whole thing, or just on the bottom?
Just on the bottom anywhere, if it has been removed, then that's a claim.
Cropped out?
Cropped out, exactly.
Okay.
And a lot of times we see artists who now incorporate their signatures in their work, and it looks really beautiful, and it's even better because if it's removed or if it's edited, you have a stronger claim under the DMCA. Having low resolution previews on your website, on your Instagram, wherever you're posting these works is really good, so no one can make high definition copies. Even when you try to increase resolution using AI, which you can do, sometimes it adds something different to it and it looks off. So it's nice if you have low resolution previews and nobody can exactly copy it. I want to mention digital signatures, blockchain. Blockchain is a topic for a whole other day, but I will talk about two really, really incredible tools that were developed by the University of Chicago. The University of Chicago came up with Nightshade and Glaze. Nightshade is a data poisoning tool. And what this means is, if you have an image, an artwork of a dog, this Nightshade poisons that data, and it will trick an AI system when it's being fed in to think it's an image of a cat. So because of that, the subject matter of your work would not be copied because the data has been poisoned, and you're not able to reproduce the same subject matter.
I love that.
Yeah, and similarly you have glaze. And glaze is what I was talking about when you cannot protect in the style of, and people are able to create in the style of so many different artists. If you glaze your work using this tool, then it prevents you to create in the style of a certain artist or a certain work or art form. So if you have let's say an impressionist painting, and if you glaze it, when it's fed into the AI system, it can be that of an abstract painting. So the form and the style of your work, along with the substance, is not copied. And coming,
I was just going to say, are there any tools like that for writing or literature or
I have
music?
not come across any for writing or literature, unfortunately. It is very hard for, I think, writing just because of the nature of ChatGPT and how if you even input any text from anywhere inside, you'll likely have a very reproduced version of it. So it is hard. For visual art, it might be a little easier using these tools. And Kelly McKernan, who I mentioned earlier, who was part of the class action lawsuit, she was really upset that her claims were dismissed because her work was not copyright registered, and she used glaze and nightshade in order to protect her work. And I loved this quote from her, and this is how it looks to the normal eye. And if you look at a glazed artwork, and if you look at an unglazed artwork, or poisoned, non-poisoned to the human eye, it's exactly the same. There's no change. But this is what it would appear in the tool when it's being fed in. And she made that art in itself as well.
Is that like an app you pay for?
So it was a tool developed by the University of Chicago that was open access, and it can be used by all. There was such a burden on it, and a lot of people were using it, so it has faced a lot of issues just because of the high use. But otherwise, you can use it, and it's absolutely free. And we were just discussing a little earlier that they might have some kind of a fee that is being charged in order to upkeep it, because it has been very difficult for them to handle such high usage. But I guess I will conclude by what we began with. You know, we have AI God, which was developed by a humanoid robot that sold for $1.08 million. And then you have a banana duct taped to a ball that sold for $6.02 million.
Oh my God.
I remember that.
So at this stage, we are wondering which one is art and who cares if it is. And that's a big question for the art market. Rafik Anadol, who is a really big artist, he had this work at MoMA called Unsupervised, and he is very well known for using artificial intelligence in his works, and he reimagined 40,000 archived images at MoMA, including Starry Night, to reproduce this and create it in the form of artificial intelligence. And when I visited it, I first thought that, oh, you know, they're just blobs, I'll probably be unimpressed, but I went there, and it was some of the most beautiful stuff that I've sseen. And it was huge on the Hyundai digital screen that they have at MoMA.
Is that like rolling? You saw it?
Yeah. I was mesmerized. I didn't know what to do.
I just wondered if you've seen, I'm sure you've seen it, most of you, the artwork. I've seen it on Instagram where famous paintings come to life. They come out of the
Yeah.
They interact with people. How is that affected by copyright? It's brilliant. I mean, it's amazing.
It is, and you know, that's a very good question for digital art, for immersive art, and also the use of artificial intelligence in it. Likely AI is being used in order to recreate those and bring them to life. But it's also a question of what the purpose of whoever is creating this is. If it's in the public domain and you're recreating it just for people to see, and if you're able to commercialize it, then I don't think they mind if it's not copyright protected. So it's tough, because the reason why people are doing what they're doing, it could be beyond the scope of what it is. But it is concerning. You are using the work of other artists. You are contributing to it in some way if you're using artificial intelligence. And like a lot of times I've seen these, and it's like, ChatGPT is going to take over your job. I'm like, please take it. I really am okay.
That's funny.
But humans doing the work, like poetry, and they're working on minimum wage, and they're trying to just live day by day while robots get to create poetry and stories and artwork. That isn't the future that we want either. So it's definitely some kind of a balance that we need, and I guess we'll see how things go, because there is so much more to cover and we are yet to hear from so many cases. But that should be all. Sorry if I went a little over time.
Thank you.